Thanks for watching. Thanks for being on. And I salute you all. Today we are under the topic of land law. Land law. We are under the topic of land law. And basically today what we are going to look at, we are going to look at three things. We are going to look at the security of the tenants by occupants, which is the lawful and the bona fide. Get another one, we shall look at acquiescence. Then we also look at prescription under the land law, or land law 1, or what they call the law about the land. So I'm going to first discuss about the security of tenure of the lawful occupants, which are the security of tenure of the lawful occupants, which are the lawful and the bona fide. These are portrayed when you read Article Section 29 of the Land Act. That's where we will find the lawful and bona fide occupants. I'll not go more on what they are because there's certain topics that exaggerate more about them. But today we are looking at the security of tenure. What do they mean by security of tenure? Security of tenure is like your right, your personal right to stay on a particular property on that land without being evicted just anyhow. You gain that right, you gain that authority, you gain that mandate to stay that land lawfully and being protected by what? By the law. That's what they mean by security of tenure. We are going to highlight some of the provisions that mandate or provide for the security of what? The security of tenure. And one of it, we'll start with the ground law, which is Article 237, sub-clause 8 of the Constitution of the Republic of Uganda. Mandates provides for the security of tenure. When you read to section 31, subsection 1 of the Land Act, provides that those lawful occupants shall enjoy the security of tenure. So put that in mind. We are looking at security of tenure. We have seen Article 237 and Section 31 of the Land Act, subsection 1, talks that those lawful or the tenants by occupants may enjoy the security of tenure. When you go further, we shall look at the rent payment. These lawful occupants, they have a certain sum of amount that they have to pay. When you read Section 32 of the Land Act, it provides that they have a certain amount of money they have to pay to the landowners. Remember, these people are not the registered proprietor of the land, but they are merely lawful and bona fide. They are there by occupants. They have to pay a certain amount, rent, they have to pay to the land owners. Then there is also have whereby the application. I'll first come to the application of the certificate of occupants, which is under Section 33 of the Land Act. You get any lawful or a tenant by occupants may go to the district land board and apply for the certificate of of occupants, of which they will give him or her the certificate of occupants. So put that in mind, or bear that in mind about their about certificate of occupants. It shows that you are the permanent You are the permanent owner of that property, given the fact your name is not on the registered title to the property, but you have the audacity to refuse conviction. Then we also have what they have. They have the right to enter into transaction. When you read section 35, subsection 2, right to enter into transaction is that they can sublet, they can lease, they can sell, they can do anything. You understand? That's they mean by right to enter into transactions. You get, and when you follow section 35, it really portrays that essence very well. So put that in mind, or bear that in mind. And when you go further, you see that we are going to see further how they enter into such, or how they do the transaction. You get, and when you read section 32A, this is A, there is A, that is the Land Amendment Act. So put that in mind. Don't look for it under the Land Act. It was amended, it was added in the amendment, this section. It talks about that the tenants by occupants may only be convicted only for non-payment of rent, of the ground rent, only. they can only be evicted for non-payment of ground rent. So put that in mind. Only, they can only be what? Evicted for the non-payment of what? Of rent. Then when you go to further, section 32 of the Land Act, not the amendment, by the Land Act, subsection 1, it talks about the circumstances, what the district land board must consider for the non-payment, for the conviction of non-payment of ground what? Rent. It talks about various, actually you must go back and read this section verbatim. It has many grounds, because here the district land board has things that it has to consider. First of it that I can give, whether the non-payment was deliberate, whether there was a mutual agreement before, whether it is violated, whether the tenant vacated the premises and there are only dependency there, whether the eviction of the tenant, it is violating his what? His enjoyment of the property. You get? So it considers many things for someone to be convicted for non-payment of what? Of ground rent. This is the district land board. So the circumstances or the things that are considered, they are under section 32 of the Land Act. So we have seen section 33 talks about the certificate of occupancy. So when we go to section 34, subsection 1, talks that a tenant by occupancy can sublet, can subdivide his property, however much is not the registered proprietor. All these things are portraying that he has security of tenure. He can do anything he wants on the piece of what? On the piece of land. And when you read this section, it talks that he can sublet and he can subdivide. But however, after the landlord is consent, he can only do these things after the consent of the what? Of the landlord. And it is not a guarantee. There's also criteria where the landlord also refuses to give the consent. You understand? So this all talks about the security of tenure. When you go to section 34.2, talks that a tenant by occupancy may be inherited. You get? However much I'm a tenant by occupancy, I'm not a registered proprietor to the land, but my occupancy can be inherited by the sons, by the daughters, the relatives, or the administrators of the estate, or the people that are put in my will. So it shows that I have security of tenure. If my estate or my occupancy can be what? Inherited. You get? By my successors. You get? So when you go to section 35, subsection 1 of the Land Act, talks that if a tenant wishes to assign the tenants to any other person, the assignment must be given a priority to the landowner. The assignment must be given to the landowner as the first option. You understand? If it's to assign the tenants to any other person, the first option must be the what? The landowner. You understand? The assignment. You get? To assign tenants. You're trying to give interest of your tenants to somebody else. The first option must be the what? The landowner, before thinking about anyone else. Then you also, when you move forward and you go to section 35, subsection 2, realize that if the landowner wishes to sell the reversionary what? Interests, to sell the reversionary interests in that land, basically if he wants to sell his land, the first person to be taken as an option is the tenant by occupancy. If the landowner wants to sell the reversionary interest, he must first tell the what? Tell the tenants by occupancy that, you know what, I'm selling my land to you. Basically, you cannot go outside and leave the tenants by occupancy and you sell to someone else, yet you have a tenants by occupancy who was there. So which means the first option must be the tenants by occupancy. So put that in mind, and bear in mind that the landowner cannot sell that piece of land to any other person if the landowner has refused. The landowner cannot sell his reversionary interest or the land to any other person if the tenants of occupancy has refused or has refused. You get? So basically, he sells the piece of land with the consent of the what? Of the tenants by occupancy. Then when you go to Section 36, Section 36 of the Land Act talks about the mutual agreement between the tenant and the landowner. What do they mean here? Mutual agreement, basically here what we are trying to mean is that the tenants the tenant by occupants or the occupants by tenants and the landowner, they come to a mutual agreement. They come and discuss matters whereby they agree how they are going to share the interest. Most so on the options of sale, it is done most on the options of sale. You get, whereby even they can come to an agreement of a tenants in common or a joint tenants. You get, whereby they agree to own land together jointly. You have seen co-ownership. They can bring that thing of co-ownership. And the criteria, as when we read Section 36, basically they go to the Ministry of Land or the District Land Board to make amendments in the title. Because here they have created what? A co-ownership and a mutual agreement. All these speculate what they mean a security of what? The new one. Then lastly, when you read Section 38A, the amendment, where you see A, that is the amendment. You get, it was just added there, it is the amendment. They say that every spouse shall enjoy the security of tenure. You get, here I want to go more because we have seen under equitable interest spouses. However much a spouse is not registered, he has just an equitable interest in land, but he or she shall enjoy the security of tenure. Because it is also a tenant by what? By occupancy. That is Section 38A. So when you read through, these are portray the tenants of occupants, of the lawful and the bona fide occupants. So basically note that in mind. This is what the tenants of occupants calls for. Then we shall go to what they call a prescription. We shall go to the prescription basically. So when you go to the prescription here, what you have to bear in mind, it was a common law doctrine, or it is a common law doctrine. What you have to bear in mind, it is a common law doctrine. And the prescription basically here comes in a way that after someone uses land for a long period of uninterrupted use, this word is key, uninterrupted use and occupation. This is the word that brings uninterrupted. However much you use the particular piece of land for a long period of time, but if you were interrupted at a certain moment, it doesn't amount to a prescription. But here you use that particular piece of land uninterrupted, or you have occupied it without being uninterrupted. Basically there you may acquire a preparatory interest over another one's land. Basically the time frame is normally exaggerated. Basically it is 20 years under prescription. Normally, they normally say 20 years. So put that in mind, 20 years basically. There's a case of Dalton versus Angus of 1881. Dalton versus Angus, it portrays that basically some of the elements under prescription, there is what they call easement, right of way. These topics, easements and right of way, they'll be more so explained in landlord 2, easements, right of way, when basically you gain an interest in someone's land for a right of way, as you hear, right of way, you have that right. However much is not your land, but you have that right. Even easement, we shall see them also in land 2. You get and this is a good case of Lomono versus Chilembe Mines Limited. Lomono versus Chilembe Mines Limited talks about prescription, or talks about prescription basically. And it was perpetrated by Justice Second, who brought out that judgment basically. Then when we go to acquiescence, acquiescence is also a concept under land law. And basically what you have to know, an acquiescence entitles to unreasonable delay in enforcing or ascertaining a legal right. What do they mean by unreasonable delay in enforcing or ascertaining a legal right? Here basically what their meaning is that you have a right, but you have failed to do what? to ensure the right. That's why they say that equity helps the vigilant, not the indolent. This is a good maxim. Equity aids the vigilant, not the indolent. You get? Not the indolent. You get? So here you have the right, but you have failed to enforce it. That is unreasonable delay. There's a case of Chitamong versus Olinga of 1985. This case talks about acquiescence, whereby if somebody fails to ask for his right in a particular piece of land or to claim his interest in land, basically he loses that interest in land. He loses it basically, and you relate to Section 29 of the Limitation Act. You get most so Section 29 of the Limitation Act related to it. And basically what you have to also know that acquiescence, unlike advance possession, you get, acquiescence is a defense, not a cause of action. For advance possession, it may be a cause of action. But for acquiescence, it is only a defense, not a cause of action. What do they mean? That you cannot go to court claiming land under acquiescence, but you can only be taken to court and you defend yourself using acquiescence. You get on a particular piece of land, but for you cannot claim that land using acquiescence. So it is only a defense, not a cause of action. You cannot take somebody in court on grounds of acquiescence when you want basically his land even. You understand? So put that in mind. And we have two elements under acquiescence. The first one, the defendant must have dealt with the land honestly, more so in the belief that it is his or hers. You understand? Secondly, the true owner must be aware that the intruder is on the land, but doesn't take the reasonable measures to ensure that he evicts you from that particular land. Those are the two elements under acquiescence. First of it, the defendant dealt with the land honestly, thinking that it is his or her. Secondly, the owner knew, but he didn't take any possible measures. You get? And unlike advance possession takes 12 years and above. Unlike advance possession, for acquiescence doesn't have particular time. It is court to determine. For acquiescence doesn't have particular time. That's why we see the case of Wandira versus Okeya. For it, they use 10 years as the time. They determined to use in 10 years. But for Lomono versus Chilembe mines, they consider 7 years. So this shows you that for it doesn't have a particular time. But however, it is court to consider. It's court to determine that this is unreasonable delay. The key point here, this amounted to unreasonable delay. So basically, those are the topics of concern of today about tenants by occupancy, the security of the tenants by occupancy, the prescription and acquiescence. Acquiescence and prescription, they normally bring them in short notes. However, even it can appear in a problem question. For you, the onus is on you to determine that this person has a defense of acquiescence. This person can claim prescription in the particular land. So understand the concepts and move forward. Thank you very much. Thanks for listening. Just subscribe to the channel. Anything that you feel that you are not certain, please put in the comment section. Thank you very much. Thanks for listening. Stay blessed.